I have Mr. Carter in the queue, and I have no others in the queue, so communicate with me if you're interested in talking on the amendment to the amendment. Mr. Carter, you're recognized for 5 minutes.
Mr. Chairman, I'll yield to, she's not ready yet. So earlier, you know, we've had this discussion and we've been talking about the significance of being able to work together. We're not doing that when we aren't looking for real solutions. Imagine if we took the level of energy that we're using now on what is tantamount to a witch hunt. No evidence, just a difference in philosophy, a difference in idea. Imagine what our democracy would begin to look like if we impeached each other just because we disagreed. It's a dangerous slope. It's a dangerous slope. To think that we would waste the taxpayers' time and money chasing windmills because we don't agree with an individual's politics, policy, or ideology. None of us would survive. I implore my colleagues, let's get back to the work of the American people. Let's talk about doing what's necessary to shore up the border. So the young ladies that came before us last week with tears in their eyes at the loss of their children never has to repeat itself. We all wept with them. We all hurt with them. We all want what's best, yet we're divided in a hoax of an inquiry where there is no substance to support an impeachment. Again, I appeal to your hearts, to your minds, to your sense of fairness. Let's get the work done for the American people. And I yield the balance of my time to the honorable lady from Texas, Ms. Jackson Lee.
The gentleman has made a very valid point about, and I thank the gentleman for yielding, about this whole idea of getting to work. As I indicated earlier, we could adjourn and reconvene as an authorizing committee to provide the Secretary with the resources that he could have the billions of dollars that he says that is necessary. I'm getting more detailed information about operational control, but as I think was said at this table before, operational control is zero. And the ability to do one's job and stay measured in one's response deals with the money and the staffing that you would have. And that's why this hearing or this markup has, I don't know if we'd say deteriorated, but has gone full circle to be a full discussion of policies, that we may agree or disagree with, and facts, such as the 57,000 that died of fentanyl deaths under Donald Trump. And we heard no outcry, as I recall that number, we heard no outcry of impeaching any of the representatives of the Department of Homeland Security. So I keep trying to get my colleagues who continue to indicate under Article 1 that Secretary Mayorkas operated willfully in violating the law. I have to raise the question of what law. And again, I bring to your attention the submissions that the Secretary has made where he has steadfastly done his job. And I think it is worth, in my last moments, recounting the work that he has done. He has removed, returned, or expelled more migrants in 3 years than the prior administration did in 4 years. Since May 12, 2023, a couple of months ago, DHS has removed or returned more than 500,000 individuals, the vast majority of whom crossed the southwest border. Total removals and returns since mid-May 2023 exceed removals and returns in every full fiscal year since 2015. I think that is worth noting. So if you're saying someone is not doing their job, they did more than was done in 2015, which certainly was not the Biden administration at that time. And the majority of individuals encountered at the southwest border throughout this administration have been removed, returned, or expelled. There is no doubt that there has been a surge in the migrant movement, but I don't know if I open my remarks with that. There is a major movement of migrants across the world. There is a major movement of migrants around the world.
The gentlelady's time has expired.
And so I would clearly indicate,
The gentlelady's time has expired.
Support my amendment. I yield back.
And I now, Mr. Senator, I think you've already spoken on this. You'll need somebody to yield to you. Mr. Ivey, I think you wanted to be, anybody on the other side want to be recognized? Okay. Mr. Ivey, you're recognized for 5 minutes on the amendment.
Thank you, Mr. Chairman. I want to speak in favor of the amendment, but briefly, I wanted to also address the Adelanto point that was made. I think it was said that there's a capacity of 1,940 at that facility and only 6 people are there. I forget who raised it, but they forgot to mention that the facility is under a court order to release all of the detainees and pause on new intakes, which I think is kind of relevant to the fact that it doesn't have more people there. And that's been in place since 2000. I think the point that was made in one of the Republican documents is that apparently the view is that the Biden administration isn't fighting hard enough to get it reopened. But I would note Department of Justice moved to stay the order, and the stay was denied. But in any event, that's just a litigation argument, which is the ultimate policy dispute. I'm sure we're not going to impeach anybody based on a litigation dispute of that type. But to get to the amendment, the reason I support the amendment is because when I go through Article 1, pretty much all of the provisions, well, there's one that references immigration court backlog, but obviously that's not, that's Department of Justice for that, as apparently as it's addressed here. So I don't know that, we should be impeaching Secretary Mayorkas for that. But the other provisions go to this basically created language with respect to impeachment. Refusal to obey the law, willfully refuse to comply, willfully refuse to comply, willfully refused to comply, willfully exceeded his parole authority, etc. Every provision under Article 1 has that kind of language. Now, the reason I'm raising that is because, as I mentioned earlier, the Texas case that the majority has cited emphasizes prosecutorial discretion, even in instances where there's mandatory statutory language. So the basis of the article that you put forward is directly contradicted by the case that you cited. So just to read it again, so that it's clear in the record, and I know what the vote's going to be. Mr. Gonzalez is already clear that this is going to move forward. But for the people who review this in the Senate, who maybe will have an open line and take a look at the language, 2 points that Justice Kavanaugh made in the Texas case. The first, as the district court found, the executive branch does not possess the resources necessary to arrest or remove all of the non-citizens covered by these 2 statutes covered in that case. That reality is not an anomaly, it is a constant. For the last 27 years since those statutes were enacted in their current form, all 5 presidential administrations have determined that resource constraints necessitated prioritization in making immigration arrests. Now, I forget who said this, but I believe one of you acknowledged that if there are those sorts of constraints, just based on the resources, you wouldn't be moving forward with impeachment. But that's basically what we've got here, as the Supreme Court's pointed out, with respect to this specific agency. We're not analogizing from a different agency. This is about Homeland Security. And then with respect to how to address it, I think the chairman and others have made the point that the only remedy available is impeachment. And again, that's not what Justice Kavanaugh wrote. Kavanaugh wrote, Congress possesses an array of tools to analyze and influence those policies, the immigration policies we're talking about, oversight, appropriations, the legislative process, Senate confirmation, and he also mentions and through elections. He does not mention impeachment. To say that impeachment is the only way to resolve these disputes with respect to immigration issues, and you're basing it on this case, you're basing it on the Alito dissent, which was, 8-1, where he references impeachment in passing, but that's not in the majority opinion. So just to wrap up, I support the amendment because based on the case that you cited, there's no constitutional basis for the standard you're relying on in every provision of that article, except for the one that references the Department of Justice, which is not in his jurisdiction. So I move to support the amendment.
Gentleman's time has expired. Chairman. Does anyone else want to? Mr. Ramirez, you're recognized for 5 minutes.
Chairman, I'd like to yield to Congressman Magaziner.
Thank you to Representative Ramirez. Just again, for those keeping score at home, 2 proposed articles of impeachment. The first one claims that the Secretary willfully ignored the law by failing to detain all migrants, when in fact we know that the migrant detention centers are at capacity, 34,000 beds, funded by Congress, 37,000 annual daily count. We know that the Secretary has released people from detention at about the same rate as the Trump administration in its last 2 years, and also that it's apprehended people at the southern border at the same rate, 78%, exactly the same rate as the Trump administration. And the Secretary, in doing so, is exercising the same discretion as all of his predecessors have. Article 2, we spoke about this earlier, that my Republican colleagues claim the Secretary lied to Congress by saying things like the border is more secure than my predecessor, clearly an opinion, not a statement of empirical fact one way or the other, and using terms like secure, closed, etc., which are open to interpretation, and even when it comes to operational control, defined as 0 people, he clarified after the fact that he meant a regulatory definition, not the statutory definition. But listen, I'm glad that my colleagues on the other side of the aisle care so much about having people who testify before Congress be honest in their statements. The Secretary has appeared in front of Congress more than any other Biden administration official, and I am glad that my colleagues care so much about honesty in those who testify before us. I have an article from ProPublica, March 2nd, 2017, 5 Trump cabinet members who've made false statements to Congress. EPA Chief Scott Pruitt stated in testimony to Congress that he had never used a private email account while he was Oklahoma's Attorney General. That was found to be false. Education Secretary Betsy DeVos stated during her confirmation hearings that she has not been involved in her family's foundation, which has given millions of dollars to groups that oppose LGBT rights. You sit on the board, Senator Maggie Hassan noted. DeVos responded, I do not. It later emerged in tax filings that for 17 years she served on that board as vice president. Secretary Mnuchin denied that his former bank had used robo-signing to improperly foreclose on homeowners. That turned out not to be true. Tom Price, Health and Human Services Secretary, insisted that the discount he got on a biotech stock was available to every single individual investor who was an investor at that time. The Wall Street Journal reported that fewer than 20 investors were offered that discount. And perhaps most notably, Attorney General Jeff Sessions, when asked in his Senate confirmation hearing if he had communicated on behalf of the Trump campaign with the Russian government during the course of the campaign, said that he had not, when in fact he had discussed the campaign with the Russian ambassador. So I'll have to go back and look. I am sure that my Republican colleagues who were in office at the time filed articles of impeachment to take these Republican cabinet secretaries to task for lying to Congress under oath in hearings. I'll have to go back and look at that and see how that turned out. And I'm going to ask for unanimous consent that this article be entered into the record.
Without objection, so ordered.
All right, well, thank you, and I'll yield back to Ms. Ramirez.
Gentleman yields back to Ms. Ramirez.
I yield back.
Gentlelady yields. Is there anyone else who would like to speak on the amendment? There being no further discussion, the question now occurs on the amendment offered by Ms.
Chairman.
Sheila Jackson Lee.
Mr. Chairman,
The gentlelady is recognized.
yeah, I'd like to put into the record,
We have rolled all UCs
these
until
are,
the end.
this is, well, it's to this amendment.
You're amending your amendment?
No, it is to this amendment statement, the Border Patrol, the Secure Fence Act is as the ability to detect, respond, and to interdict penetration into areas deemed as
Does somebody
high
want to yield
priority
to Ms. Sheila
with threat
Jackson Lee?
potential.
Mr. Menendez, you're recognized for 5 minutes.
Thank you, Chair. I yield my time to Ms. Sheila Jackson Lee.
I thank you. I was going to ask, but I appreciate it very much. Thank you. This bears on advocating for the amendment, Mr. Chairman, and so I guess this is part of the debate, and I thank my colleagues for their courtesies. We have gone all around and around about operational control, my friends, which might be the most glaring aspect of Article 1, where we say the willful violation of the law. And we keep using this very elusive act that I don't think anyone has been able to comply with. So it is interpreted as this: the Secure Fence Act statutorily defines operational control as preventing all unlawful entries into the United States. No administration had ever met that standard, and a secretary that is the boss of that particular agency can rely upon representations that the efforts have been made to do their jobs at the various levels, so that the Director of Customs and Border Protection, the Director of Border Patrol can make the representation that they're in the field trying to do this. In 2007, after the act passed, the Border Patrol interpreted the Secure Fence Act as the ability to detect, respond to, and interdict penetrations in areas deemed as high priority for threat potential or other national security objectives. It didn't say zero, though we've now got an interpretation that says zero. It interprets it to do their job. And so if you ask me the question as Secretary of Homeland Security, is my staff doing their job? Well, based upon the interpretation of my professional staff, my staff in the field, they are working on detecting, responding, interdicting to the various penetrations. It is beyond preposterous to take the position that Secretary Mayorkas maintained that DHS achieved operational control as would be narrowly defined by the Secure Fence Act. And that means that every aspect of interdiction, if you will, was adhered to. So my point is, again, with my concluding remarks to this, the Constitution is a very serious document, and it was a document created for the worst level of abuses and the highest level of actions against the American people, which are treason, bribery, high crimes, and misdemeanor. And I frankly question using the impeachment proceeding for acts of employees who are attempting to adhere to guidance given to them by laws that are very difficult to potentially adhere to without the billions of dollars that we were alleged to have asked for and did not get, or that we should have asked for and did not get. All of these components should be put in the category of job performance or policy disputes, but they should not be put in the context of impeachment. John Marshall indicated the Constitution intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. This was a living document, or is a living document, to try to relate to the day-to-day affairs that are occurring. I don't know if our founding fathers would have ever expected this country to be this size, this large, or to have any concept of coming across the border, the land borders. But here we are. And I believe that this Constitution should not be taken lightly, and it should be addressing human crisis. And the human crisis should be done with all of us working together, Democrats and Republicans, on how best to secure this border. And what we're doing today does not in any way come up to the front door of that problem or solving that problem of working together on securing this nation. I have no doubt that Secretary Mayorkas wanted to secure this nation, wants to secure this nation, and will continue to work with this administration and all of us to ensure the safety and security of the American people. Please support the Jackson Lee amendment. With that, I yield back.
The gentlelady yields. There being no further discussion, the question now occurs on the amendment offered by Ms. Sheila Jackson Lee. All those in favor say aye. Aye. All those opposed say no. No. In the opinion of the chair, the noes have it, and the amendment is not adopted.
Roll call.
A recorded vote is requested pursuant to Committee Rule 7C. Further proceedings on this question are postponed. Rolling the vote. Do any other members wish to bring an amendment? Are there any other amendments? Mr. Correa. Mr. Correa, you're recognized.
Thank you, Mr. Chairman. I have an amendment at the desk, amendment number 59.
Mr. Chairman, I'd like to reserve a point of order.
Point of order is reserved. The clerk will distribute the amendment. The clerk will report the amendment.
An amendment to the amendment in the nature of a substitute to HRES 863 offered by Mr. Correa of California, number 059. Page 15, line 21, strike Article 2 and all that follows through page 20, line 11.
I'd say without objection, the reading dispense with, but you just read it, so.
Mr. Chairman, I object to the waiving of the reading of the amendment and ask that it be read in full.
He just read it.
Okay.
He just read the whole amendment. Do you want him to read it again?
Can you do that, sir? We're only, this is the second amendment out of 40. Let's make sure we do it right.
Okay.
Mr.
I
Chairman.
mean, are you serious? Okay. That's what I thought. Okay. All right. Actually, we have okay. All right. We will hear this amendment when we come back from a dinner recess. We're going to give you guys an opportunity to go get fed and be ready because I think it's going to be a long evening. We will adjourn we will recess and return at 7 p.m.
Mr. Chairman. Mr. Chairman, can I withdraw my point of order?
Point of order is withdrawn, and the ranking member is recognized for what purpose?
Well, first of all, Mr. Chairman, at the beginning of this markup, the committee granted the chair recess authority by unanimous consent. At the beginning of the last vote series, the chair declared the committee would reconvene at 4:40 p.m. upon conclusion of the floor vote series. The committee, in fact, did not reconvene until 5:22. What can members expect from the chair in terms of its use of the recess authority for this markup?
I anticipate that following a dinner break, we shouldn't have a need to recess again. I genuinely believe that. So, I mean, unless something unforeseen comes up, but that's been the plan all along.
So we reconvene at
Reconvene at 7 PM and everybody in their seats at 7 PM. We stand in recess.